Mr. Dornburg, good afternoon.
Good afternoon.
I want to talk to you a little more about the chair that Mr. Burrisoff discussed with you. So to be clear, you built that chair?
Yes, I had help, but I designed it.
You and the other fraternity members designed the chair?
Yes.
And then you and the other fraternity members went about building it?
Yes.
You don't have a degree in engineering, do you?
Well, in a couple months I will, but no, you're right, I don't have one.
And at the time that you built that chair in 2014, you weren't just 2 months away from that degree, were you?
That's true, then I was a year away.
And you didn't at the time hold a job in, say, carpentry, did you?
No.
You worked actually at a local rec center?
That's right, yeah.
Let's talk about this chair in particular. You drew up plans for this chair, right?
Yes, that drawing, you're looking at it.
Now the jury will have a chance to see it a little more close up, but for their aid I want to read exactly what's on certain parts of this drawing. Now, here it says, warning sign, question mark, is that right?
That's right.
And it looks like that phrase, warning sign, has been X'd out.
Yes, that's right.
And that's because, as you told us on direct examination, you decided against one, didn't you?
Yes.
So it occurred to you to add a warning sign to this chair, yes?
Yes.
And then you made a decision to not put one up, right?
That's right.
A warning sign could have been an 8 by 11 inch piece of paper, right?
Yes, it could be, yeah.
It could have taken lots of forms, right?
Yes.
It could have said, do not climb on a piece of paper, right?
Yeah, that wouldn't have made sense because I fully intended on climbing it.
Well, bringing you back to my question, because we'll talk about that in a moment, it could have said, do not climb on a piece of paper, right?
Yes, there could be such a sign.
A piece of paper just simply maybe taped up to the lifeguard chair, yes? After spending all of this time building the lifeguard chair, you never put any such sign on the chair, did you?
No.
Now, it also says here, sandbags for stability, is that right?
Yes, that's right.
That means that you added sandbags to make sure the chair didn't fall over?
Yes.
So you were concerned that it might fall over?
I guess you could say I was concerned that if sandbags were left out, then yeah, it could have fallen over.
If sandbags weren't there, it could have fallen over.
Right.
And in fact, you put this chair next to the water of that pool, yes?
Yes, that's right.
Now I want to be clear, that pool was 2 to 3 feet deep, wasn't it?
Yes, that sounds right.
It wasn't a pool with a shallow and a deep end, was it?
No.
So it wasn't a pool that might be 6 feet deep in one place.
No.
And you put the chair next to the pool to break someone's fall if they fell off the chair, yes?
Yeah, that thought went through my mind. Yeah, that's right.
In other words, if someone fell off the chair, you hoped that 2 to 3 feet water would break their fall, yes?
Yeah, also because that's where you put a lifeguard chair next to the water.
So bringing you back to my question, you put the chair next to the water so that the 2 to 3 feet pool would break their fall?
Yeah, that's right.
This chair, it says 12 feet here, doesn't it?
Actually, 12 feet plus. This party was no joke.
This party was no joke?
That's right.
You were serious about this party being fun time, right?
I am always serious about having a good time.
You're always serious about it. Is that a yes?
Yes, that's right.
So it's 12 feet plus on that diagram?
That's right.
And the chair ended up being over 12 feet?
I didn't measure it, but it was about 12 feet.
Your Honor, permission for the witness to stand up as a demonstrative for the jury?
Any objection? No objection, Your Honor. Go ahead.
Mr. Dornburg, I'd ask that you stand up at this time. About how tall are you?
6 feet.
So that lifeguard chair, you would guess, was twice as tall as you are now.
I think so. That's right.
Objection, Your Honor. I'm actually going to move to strike. The witness is only speculating as to the height, and without being able to recreate the exact conditions for the jury, I think this is actually improper speculation based on the evidence he's already given.
May I be heard on that point, Your Honor?
You may.
This witness actually was the one who built the chair. He testified he designed it, and he testified to Mr. Burrisaw on direct examination that that diagram accurately reflected the chair that was in fact built. He just told us the chair was about 12 feet. It's not speculation. It's something he in fact saw.
I'm going to overrule the objection. I think the witness is in a good position to speak as to the height of the chair.
So that chair, it was about 2 times the height that you are, right?
Yes, that's right.
You may take a seat. Mr. Dornburg, you met Kay Denning's friend, Chris Bloom, on the night of the party, yes?
I know his name is Chris. Yeah, I did meet a Chris.
You met a Chris when Kay Denning was walking in front of the frat house before the party,
Yes, that's right.
and you got his number as well as Kay's, right?
Yes, that's right.
You've texted Chris, haven't you, since the incident?
Not that I know of.
You don't recall ever sending a text message to Chris Bloom?
No.
I'm now showing opposing counsel what's been marked Exhibit 8. May I approach the witness?
You may.
Mr. Dornburg, I'm handing you what's been marked Exhibit 8. That's a copy of text messages sent between you and Chris Bloom, right?
This reflects that I texted somebody named Chris. As I was saying, I don't remember texting the Chris from that night, and I'm assuming this is a sort of true record, so I obviously texted a Chris, but I don't remember texting him that night.
You gave a deposition in this case, didn't you?
Yes.
And during that deposition, you were asked whether you'd seen this document before. Or sorry, you were shown that document during the deposition, right?
Well, the lawyer definitely asked me about texting Chris, and I think what I told him was that Chris had texted me, but I never remembered seeing those. And so I honestly can't remember if these texts were the texts that that lawyer showed me or not.
So you don't remember seeing texts from Chris Bloom?
No, I don't.
You don't remember ever texting Chris either?
No, I don't.
Now, I want to be clear. You just told us that you don't remember texting Chris the night of the accident, that is May 24th. Is it also your testimony that you don't remember texting Chris on May 31st?
That's correct. I don't remember texting Chris.
Your Honor, may I have a moment?
You may.
Do you mind if we give a moment to Andrew Dornburg's testimony? And now it's your testimony that you've never seen this document before?
I've been asked about texts before, so I'm aware that apparently I received texts from Chris, but again, I can't remember if these were the ones I was shown at deposition or not.
When you were shown them, I'm now approaching you with a copy of your deposition, Mr. Dornburg. And Mr. Burrisaw, would you mind getting the other copy out of me? Mr. Dornburg, I just handed you the 6th page of your deposition, so let's focus on that. And I want to direct you to the top third of that page where it mentions Exhibit 8. Now, are you having trouble remembering what text messages and exhibits you were shown at your deposition?
Well, I definitely agree that I was asked about text with Chris then. This is a record of text between me and Chris, apparently. But again, since I never remember actually getting the text on my phone, I can't really remember what the content was, either at deposition or whatever.
So I hear that. So to clarify, I want to make sure we know the difference between what you saw and whether you've seen this exact exhibit that you've held in your hands, whether or not you remember seeing text messages themselves. Have you seen Exhibit A before?
Yeah, this does look a lot like what I was shown at deposition. I recognize it, but I just can't remember if the content is the same. I recognize it.
So that was what you were shown at your deposition?
It looks like it.
And is that a true and accurate copy of what you saw at your deposition?
I have no idea.
Your Honor, at this time, we'd ask the court to take judicial notice that there's been a stipulation that this is in fact a true and accurate copy of what was provided to the witnesses, and that this exhibit is authentic.
Defense prepared to so stipulate it.
There's already a stipulation to the authenticity of this, Your Honor. I think part of the confusion is just about the timing of the text with the witness. From what I recall from the deposition, this is what the witness saw at that time and identified, and we've stipulated to its authenticity since then.
The court will take judicial notice of the authenticity of the document.
And at this time, Your Honor, then we move to enter Exhibit 8 into evidence.
Any objection?
Yes, Your Honor. I don't think proper foundation has been laid to show that this either isn't hearsay or doesn't fall within a hearsay exception. Specifically, I want to focus the court's attention on the last text message in this series, which is not only subject to our hearsay objection, but also to a 403 objection, that it lacks probative value, but would be unfairly prejudicial to the defense.
May I be heard?
You may.
So to clarify for the court, there are two sets of text messages we're talking about here. The first are 3 text messages from Chris Bloom to Andrew Dornburg. None of those are being offered for their truth. In fact, Chris Bloom will be testifying, or has testified and has testified to the content of these messages, so there's no need that they be entered for their truth. The second set is a text message from Andrew Dornburg on May 31st of 2014. That would be an admission by a party opponent. We contend that he was acting within his capacity as a member of the fraternity, the defendant, when he sent it, and so it falls under that hearsay exception.
Any response?
Yes, Your Honor. As to the party opponent exception to the hearsay prohibitions, we haven't had sufficient evidence that at the time this text message was sent, Mr. Dornburg was acting in his capacity as a secretary or treasurer of the fraternity. If I may make an offer of proof, the content of this text message, were you to review it, Your Honor, would demonstrate that this was sent in a personal capacity by Mr. Dornburg himself, not as an agent of the fraternity. And it's only conditionally relevant if it was sent as an agent of the fraternity. That makes its probative value very limited, and we lack foundation for that probative value. Whereas in